Okay, we're
Good morning, everybody.
If you want to handle the technicalities.
No, I don't.
good morning, David.
139, Psalm 139. And I think if everybody could mute him or herself while we're doing this part of the program, I think it would be easier for everybody. So Psalm 139, New Revised Standard Version. O Lord, you have searched me and known me. You know when I sit down and when I rise up. You discern my thoughts from far away. You search out my path and bring my lying down, and are acquainted with all my ways. Even before a word is on my tongue, O Lord, you know it completely. You hem me in, behind and before, and lay your hand upon me. Such knowledge is too wonderful for me. It is so high that I cannot attain it. Where can I go from your spirit, or where can I flee from your presence? If I ascend to heaven, you are there. If I make my bed in Sheol, you are there. If I take the wings of the morning and settle at the farthest limits of the sea, even there your hand shall lead me, and your right hand shall hold me fast. If I say, surely the darkness shall cover me, and the light around me become night, even the darkness is not dark to you. The night is as bright as the day, for darkness is as light to you. For it was you who formed my inward parts. You knit together me in my mother's womb. I praise you, for I am fearfully and wonderfully made. Wonderful are your works. That I know very well. My frame was not hidden from you when I was being made in secret, intricately woven in the depths of the earth. Your eyes have beheld my unformed substance. In your book were written all the days that were formed for me, when none of them has yet existed. How weighty to me are your thoughts, O God. How vast is the sum of them. I try to count them. They are more than sand. I come to the end. I am still with you. Let's pray. Again, it seems that we are coming together heavy with the sorrow of death. This time for so many innocent victims in Ukraine. We pray for them, yet praying for them seems so little. But we believe it's great. Help those who are in power to figure out a way to protect these people who are being ground into dust by these bombs. Today we think about death in a different way. Help us to remember that nobody ever woke up, no woman ever woke up and said, good, this is the day I've been looking for, I get to have an abortion. Nobody talks that way. This is a sad situation that occurs only under difficult circumstances. So help us to keep that in mind. Help us to have some sensitivity here, some compassion for those who are facing this difficulty. We pray in Christ's name. Amen. This morning, we have the good fortune of hearing from Donna Carlson, Reeves KO. She's a very good friend of ours, but sometimes we take each other for granted. So let me just remind ourselves that she's a graduate of La Sierra University and Loma Linda University with a medical doctorate there. She also has a degree in public health, which we mention less often, from the University of California at Berkeley. And then she also finished a law degree at University of Southern California, and is a lawyer, practicing lawyer in the state of California. She's also board qualified in pediatrics. So it's hard to think of anyone better to discuss this matter than someone who's both an attorney and a pediatrician. I think there are about 1,500 people in this country, the United States of America, who are both MDs and JDs, but that's not very many. And so it's a very small and distinguished club. We have talked about this before, but today we're going to look at two current cases, and actually a third one showed up in Florida, I think yesterday's, and it's quite similar to the one in Mississippi. So if we look at these two cases, we will benefit greatly. On all of these issues, the question that comes to my mind is, how should we distinguish between those things which we believe to be wrong to make them illegal as well? Paul Ramsey, who taught Christian ethics at Princeton for a long time, said that as far as he was concerned, that was the most difficult question for Christian ethics. So we need to keep that in mind as we move forward. These legal issues are very important to us because the law is a ship floating on the sea of ethics. So here we go. Over to you, Donna. Thank you so much for being with us and sharing with us this material, abortion jurisprudence in the Supreme Court and elsewhere. Sure enough, Roe v. Wade and its progeny. Thank you so much.
Can you hear me?
Yes.
Okay. Well, good morning, everyone. I'm sorry, as you can see from this first slide, I forgot to change the date. I did a variation of this last week for the OBGYN grant rounds.
No problem.
Jeff reminded me to tell you why I'm wearing yellow and blue this morning. These are the colors of the flag of Ukraine. Just a small protest there, or a small evidence of support. Okay, I have done this talk as we've just been reminded by Dave a couple of years ago. So some of this will be review. I will go through the early stuff pretty quickly, but I think it's useful to look back at how Roe v. Wade became the law of the land. What were the social issues at the time that lie behind the decision, and have they really changed? And so we'll go ahead now. Oh, the other one. Nope, they're not. I'm sorry, we're not advancing yet.
Sometimes if you click somewhere, you got it? Okay.
Yeah. Okay, Jeff's done that. This is the most, I only put this up to show the relevance of the topic at this time and the ways in which some of the issues surrounding Roe are expanding. This is the latest issue, the last issue of Law, Medicine, and Ethics, which is a journal to which I subscribe. And what you'll see in here, a couple of, let's see if I can, I don't know if you can really see very well, but there's a couple of articles in here talking about disestablishing hospitals. This is an article written about the vast number of religiously affiliated hospitals, particularly Catholic hospitals, it talks about mostly, and then also vaccine mandates and religion. The disestablishing hospitals, I think, is especially important and of concern to us here at Loma Linda, because the author argues that if religiously affiliated hospitals, of which there are many in the country, are receiving other kinds of federal funds for Medicare, for instance, should they not be required to offer, quote, all healthcare of services that would begin to include abortion and end-of-life physician-assisted suicide, and perhaps even sex change procedures. And the suggestion is that if we don't do that, then why are we paying heart attacks, for instance?
I want to enjoy.
Just gonna be sure the video's off while I'm doing this.
Yeah.
Doesn't look very good.
Oh, okay. And, oops, wrong direction, sorry. I always begin these with a picture of Justice Blackmun and his quotation from the Roe case: abortion raises moral and spiritual questions over which honorable persons can disagree. And he talks in that case about the history and tradition, and you'll hear those words again. If any of you had a chance to listen to the oral argument in Dobbs, it's a couple of hours. To me, it's very enlightening because all of these old phrases recur, and the Supreme Court justices completely, I mean, not completely, but frequently refer to history and tradition as justification for whatever their positions are, whether before or against. But history and tradition of this country is mixed. Ancients had one view. The Hippocratic Oath says no, physicians should not facilitate abortion. This is 400 BC, of course. English common law, there was a quickening date after which, if an abortion was attempted, that would lead to death or transport to Australia. The Ellenborough Act was 1803, so you see this is about the time shortly after our own Bill of Rights was passed, and that included in that act was included penalties of death for the intentional killing of a pregnant woman and the child she was carrying. We followed the same English law for about the first 150 years until the Constitution. After our Revolution, 1787, we wrote the Constitution, but then people were unsatisfied and especially urged Madison, we need a Bill of Rights, and similar to the one that the state of Virginia had. And so the Bill of Rights was passed. Excuse me. I will get it. Okay. The most important, I've listed here the most important constitutional amendments to which the current cases refer. And I don't know why this keeps. Okay. The 4th, the 9th, the 10th, and eventually, I'm sorry. And eventually the 14th. 4th, 9th, and 10th are all 1801 because that's when the first 10 were adopted. And these are the amendments to which the lawyers who were arguing for Roe referred. The 4th, all of us I think remember, is the right of the people to be protected against unreasonable searches and seizures, to be secure in their persons. The 9th and the 10th are less familiar, but they go together. The 9th is it says that whatever, despite the fact that some rights are mentioned in the Constitution, there are others that are not denied and cannot be disparaged because they are retained by the people. And by the people means the people of the states and the general population. The 10th Amendment says powers that the states don't give to the Constitution, and the Constitution doesn't prohibit to the states, are reserved to the states respectively and to the people. And that is the clause on which people who are seeking to overturn Roe hang a lot of hats, because they say, or it is said that, remember, healthcare, among many others, are reserved to the states. And that's why now, of course, we have different laws in different states. Licensures requirements are different depending on which state you live in, and so forth. But then the 14th, one of the civil rights amendments after the Civil War, no state shall make or enforce any law which could deprive any person of life, liberty, or property without due process, nor deny to anyone the equal protection of the laws. Again, this comes in both of these, the liberty, the substantive due process. They call it substantive due process. In other words, it's not just you go through the motions of a procedure, but actually what is the nub of the right or the liberty at issue. And that portion of the 14th plus the equal protection law, the equal protection clause, becomes important. History and tradition, 19th century, lots of laws banning abortion. And there were reasons for this. The medical profession didn't like the midwives taking over things, and they took over, or at least passed laws banning abortion, although they themselves wanted to continue to be able to make the decisions about it. The Civil War, we lost a lot of people. We needed to replace them. So again, abortion was frowned upon. At the same time, there were famines. You remember in Europe, lots of immigration of European Catholics, the Irish, the Polish, the Italian, and the Northern Germans came in mass. We wanted them because, again, we needed the population, but they brought with them the Catholic religion. And so were involved, when they were involved in politics, they were putting forth or supporting bans on abortion. And those of you who are theologians can tell us more about, excuse me, thank you. I need to give this, the control of the slides to Jeff. There were also in the 19th century, part of the history and tradition, where women's rights activists were becoming more prominent. You see here pictures of Susan B. Anthony, Katie Stanton, Elizabeth Cady Stanton, and of course Ellen White, who, at least in our tradition, hinted that men needed to have their appetites controlled so that women wouldn't have to be born down with so many children. And then in 1873, now remember the Civil War ended in 1865, so we're just a few years later. Anthony Comstock was the Postmaster General at the time, and he prohibited the Articles of Immoral Use, which included a variety of things, including birth control measures for transmission in the United States mail. And that was good law for about 100 years. I'm not going to talk much about the evolving views of the medical profession. We sort of reflected what was going on in the society in general, and the AMA changes, the American College of Obstetrics and Gynecology changes. There are really interesting cases now about therapeutic abortion for transgender men, which is something I hadn't realized was a problem, but apparently it is. ACOG has mixed positions, just as the rest of the population does. In 2019, the AMA issued its general rule: physician may perform an abortion in accordance with good medical practice and under circumstances that do not violate the law. So that's a broad generalization. But in last year, I was able to get hold of a statement by Advent Health that Advent Health has, and it reflects, I think, the 2019 AMA. If you look at it carefully, it's also very general. Adventist health hospitals do not perform elective abortions. All other questions regarding the termination of a pregnancy are left to the private decision-making between the mother and her physician. So we are following pretty much the same thing. Okay, Comstock ends in 1965, and I always encourage students to look around in the society or what was going on at the time these major and watershed cases came up. In 65, if you think, where are we as a country? Well, we're in the middle of the Vietnam War, but people are coming home. They're bringing home with them venereal disease, concern because so many are dying young. People are beginning, sexual mores are loosening from the influence of war, as war usually does loosen sexual mores. And Griswold versus Connecticut was a case that you may be familiar with. Again, it is frequently cited in more recent cases. Connecticut had a law against the sale of contraceptives because those are articles of immoral use. But Dr. Griswold is a woman physician at Yale who promoted and enabled her patients to use contraceptives. She was sued. That case went to the Supreme Court, and at that point, the right to marital privacy was established. And if you're able to look at the decision here, it's 7-2. So that's a pretty definite answer from the Supreme Court. And it's written by Justice Douglas. He used to be known as Wild Bill Douglas. At the time, there were 3 Williams on the Supreme Court. It's kind of interesting. But he was a very, very liberal. And some people say he was in favor of contraceptives because he was himself such a philanderer. But we'll leave that to the side. But this case establishes the right to marital privacy. And this is kind of the first time that the Supreme Court really starts talking about the right to privacy. This is created in Griswold. They find the right again in the 4th, remember, the right to be free of unreasonable searches and seizures, and the 9th Amendment's right of these decisions being left to the states. And in what Douglas described as the penumbra, the emanations, the sort of vague, thin clouds surrounding the due process clause of the 14th Amendment. Remember, that's the first part of the 14th Amendment, the substantive due process. In there is the right to privacy, not just the right to have us go through the motions. A few years later, so 65, this is now Eisenstadt versus Baird, is just a year before the Roe decision. This is a case over here. This is Professor Eisenstadt, was not a physician, was a professor at a smaller college in the Northeast. He ended his lecture supporting, excuse me, some water. Oh, good. Supporting the distribution of birth control materials. He ended his lecture by handing a tube of foam to a 19-year-old single person in the audience. It was a setup. He was sued. And Baird was the sheriff who had arrested him. That went all the way up again to the Supreme Court. And this time the court said, well, single people deserve equal protection, again, under the 14th Amendment. And they have just as much right to privacy as married people do. And and this is the language of the court, if the right of privacy means anything, it's the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. So those two. And now we come to Roe, 1973. Again, most of you know this case. These are the lawyers here, Sarah Weddington and Linda Coffey. This is the lady who's the lead plaintiff, Norma McCorvey. And this is poor Henry Wade. Henry Wade was the Attorney General of the state of Texas. And and when they sued them, regarding this law, Wade, as is usual, a government official, is named as the defendant representing the state. This starts in Texas, and you'll see as when we get to the end that most of the current cases come at least out of the same circuit court, of which Texas is the largest state, Louisiana and Mississippi being the other two in the Fifth Circuit. Okay, so Roe basically sues and says there's a right to abortion and privacy, again, based on the 4th, 5th. Well, the 5th is in here as kind of a repeat of a portion of the 10th. 9th, 10th, and 14th Amendments. So again, every time one of these cases comes up, the lawyers on both sides go back to these amendments in the Constitution. Also, besides these constitutional amendments, Roe specifically invokes the decisions in Griswold and Eisenstadt. And again, if you listen to the most current case, you will hear again about Griswold and Eisenstadt and the rights to privacy, autonomy, and equal protection of the law. Okay. Oh, the Roe decision, interesting, by 7-2. Majority opinion is written by Blackmun. Blackmun, remember, had been in-house counsel for Mayo Clinic in Minnesota for about 10 years before he's elevated to the court. And the other men, this is Warren Burger, Thurgood Marshall, Justice John Paul Stevens, and this is Wild Bill Douglas. This is, let's see, what is that, Powell, Justice Powell, and I can't quite remember who this is. But the nub of the decision was as a right to privacy established by, again, Griswold and Eisenstadt, and includes the right of a woman to choose an abortion up to the point of viability. And this is the case that established the trimester framework, which now has, quote, been abandoned, but I think in a way it really hasn't been, because the trimester framework is not that different from a viability analysis. Maybe the weeks have moved a little bit one way or the other as medical ability to keep a fetus alive or a baby alive has advanced, but it's still approximately the same. Trimester framework of Roe, first trimester, the woman has an unimpeded right. This is the stage prior to the end. But if you notice, it mainly talks about the medical judgment of the attending physician, of the pregnant woman. She wants it, but the attending physician gets to make the call in this early stage. Remember, it was an all-male court. The second trimester, the state begins to develop an interest in the life of the unborn future citizen, as well as the mother. And so now, according to Roe, the state can impose some reasonable restrictions and may regulate the procedure in ways that are reasonably related to maternal health. Finally, in the third trimester, according to Roe, the state may ban abortion. Because now we have a viable fetus and the state's interest has matured to the point where it can begin to actually ban the procedure. I'm not going to talk. There was a companion case. Roe needed to make this a class action suit, which the lawyers very smartly did by including some other plaintiffs and a companion case. But again, it was all generally related to the physician's right or the medical judgment that a physician was enabled to exercise. Go ahead. Okay. I quote again, another quote I think at this point is important from Justice Blackmun. It was also in Roe. He not only said, this is a troublesome area, he said, we need not resolve the difficult question of when life begins, because people trained in medicine, philosophy, and theology, that's all of this Sabbath school class, are unable to arrive at a consensus. Then the judiciary at this point can't do it either.
Go ahead.
Okay. There were two dissents in Roe, and I talk about them because they are, again, the dissents, and the arguments in these two dissents are the ones that are still used by people who oppose Roe or are arguing for it to be overturned. Byron White was a new justice, relatively new appointed. I should say Roe was argued twice. The first time, the first year it was argued, it was postponed over to the next year because the court had an incomplete complement of justice justices, and they did not want to issue a 4-4 decision in a case of this significance. So they waited until they had the full 9. But Byron White was one of the dissents, and he said, there's nothing in the language or history. Remember, we were talking about history and tradition of the Constitution to support the court's judgment. The court simply fashions and announces a new constitutional right for pregnant women and invests that right with sufficient substance to override most existing state abortion statutes. At the time of Roe, and I may have the numbers on another slide, there were about 30 states that completely banned abortion. There were 16 that had some exceptions for the life or health of the mother. And what Byron White is saying here is that by coming up with this new right, the court has suddenly abrogated all of those statutes of the states without any real input from the states. Okay, so he calls it an exercise of raw judicial power. And he accused the majority of valuing the convenience, whim, or caprice of the mother more than the life or potential life. This is the second dissent. This came from William Rehnquist. He said, again, to reach this result, the court has to find a right within the scope of the 14th Amendment. It was apparently completely unknown to the drafters. So he is also pointing out that when the 14th Amendment was written, there was no such right. And so now we're somehow finding it, as he put it, Justice Douglas was stumbling around in the penumbra and came upon the right to abortion. Okay, and this is again just what he said. Okay, what happens after Roe, and this is significant because it has every year been reattached to the appropriations bill for Health and Human Services. It's the Hyde Amendment, and it has shown up repeatedly at the Hyde until this year. By the way, it's unlikely though that the appropriations bill is going to be passed, and somebody will try to reattach Hyde. But it's been here. It's been on since '77. This is now 3-4 years after Roe. Senator Henry Hyde was a very anti-abortion senator from Illinois. But the Hyde Amendment, which pertains only to federal money, prohibits federal money to fund abortions for all, wherever there's federal money. So federal employees, Medicaid, Indian Health, military, veterans, in all these areas, federal money cannot be used to fund abortions. There's a strong movement to get rid of Hyde. As you can see, it has to be reattached every year by somebody because it's a rider. It's not an actual statute or on its own. But in most cases, or in many cases, the states that are in opposition to Hyde, by which I mean pro-choice or pro-abortion, use their own money. And California has a very strong anti-Hyde and pro-abortion or pro-choice statute, and even a constitutional amendment in the state of California. The 3 cases following Roe take a quick look at, because again, their arguments are still here. City of Akron, Webster, and Planned Parenthood versus Casey. You probably heard a lot of talk on the news about Casey. It's the most significant of the 3 cases that came quickly after Roe. So 10 years after Roe, 1983, is the City of Akron. The city passed an ordinance that had 17 restrictive requirements, all sorts of things that they wanted to have attached to the right to, quote, right to abortion. Parental consent, specific disclosures by the physician, a 24-hour waiting period. All of these, as you know, are re-showing up in the recent cases as hospitalizations for second trimester abortions. They had an interesting one, which fetal remains must be treated with respect and buried in something approximating a funeral. Most of these were discarded by the court, but oh dear, here we are. And the court said, look, it's 10 years. Why are you still asking us these questions? And these legislatures, whether the city council or the states, are questioning our reasoning. They are trying to regulate and to expand the limits of the state's authority to regulate. And, says the court in irritation, arguments continue to be made in these cases as well that we erred in interpreting the Constitution. And that's the same argument that's made now. It was made in the dissent, if you remember, by both Rehnquist and White. They said, look, it's not in the Constitution and you're making it up. Okay, nonetheless, and the doctrine of stare decisis, that is, something has been decided that I think literally means let the decision stand. We're not going to overturn something that unless we have a really good reason. O'Connor now is on the court in my 1983. She's the only woman there. She dissents from City of Akron, but she articulates in her dissent the thing that you again will hear a lot about because it's the current standard or proposed of the undue burden. SR means standard of review. Standard of review is a principle that the Supreme Court will use when it evaluates statutes that infringe on what are considered fundamental rights. So just briefly here, your right to free speech, which is specifically mentioned in the First Amendment. In order for the state or the city or any government agency to limit your right to free speech, they have to have the state has to have a very, very good reason. And so the court will look with very stringent suspicion on any kind of a government restriction. On the other hand, that there may still be some restrictions. And the most famous example, of course, is Justice Holmes saying the right to free speech does not include the right to shout fire in a crowded theater. There are time, place, and manner restrictions on even fundamental rights. Next one that was post-Roe that I think is still very relevant. And remember, there were lots of cases post-Roe, so I picked out just a couple. Webster, this is, oops, can you see that? I can't tell. Nope. Jeff, how do I go back? Sorry. There we go. Webster is a Missouri case, and it begins with the line, the life of each human being begins at conception. So Justice Blackmun wasn't sure, but the state of Missouri knows. And when SCOTUS, the Supreme Court, is reviewing this case, they dismiss that preamble by saying, right off the bat, they dismissed the preamble by saying that was just dicta. It really wasn't a holding of the court or of the state statute. It's just something that was thrown in gratis at the beginning. But the Supreme Court upheld 5 of 4 prohibitions on the use of state funds, facilities, and employees. That's very important because Missouri had said no state money now can be used to fund abortion, to support the facilities or the employees in assisting with or counseling on abortions. This is an attempt to limit the speech of people involved in abortions, whether the physician or even the counselor out somewhere else. The upshot is, despite this, quote, liberty interest from the 14th Amendment in a right to abortion, which Roe had talked about, the court said governments have no duty to pay for the exercise of this so-called right. This is basically a state version of the Hyde Amendment. Remember, Hyde forbids the use of federal funds, and Webster now is the first state to say, and not only that, we don't have to use our funds either. And this is where the implication begins to become evident that a liberty interest is not the same as a fundamental right. Or at least this is what the critics say. This way. Okay, this is Planned Parenthood versus Casey, the most important post-Roe case, the one which you will hear the most about, both in argument of the Supreme Court, you'll hear about it in all the news commentaries about the issue. Everybody goes back to Casey. Casey was a state, Casey, by the way, was the governor of the state of Pennsylvania at the time. And he supported this Abortion Control Act. So the act is passed in 1982. It had 5 requirements. And you'll notice the act is in 1982. We don't get a decision from the Supreme Court until 1992. So it takes 10 years for this case to work its way up to the Supreme Court. So the wheels of justice really do, grind slowly. But the 5 requirements were informed consent, which must be contained by a physician, a mandatory 24-hour waiting period, the spouse to be informed, parental permission required for a minor, and the facility had to keep records and reports and file those with the respective government agencies. It did have a provision for medical emergencies under which the waiting period could be waived so that you didn't have to wait 24 hours. But those were things that necessitated an immediate abortion to avert the mother's death. So we're going to look, for those of you who have medical background, things like placenta previa or bleeding disorder, or maybe an abruptio, something which poses a serious threat of substantial and irreversible impairment of a major bodily function. So this would be like renal failure. So the act is passed in Pennsylvania. The plaintiffs are 5 Planned Parenthood clinics and a group of physicians. So they challenge the law and say this is unconstitutional. This impinges on our liberty interest. The decision explicitly affirmed the basic holding of Roe, but allowed more restrictions by the state. All of those 5 provisions that we looked at, all were upheld except the spousal notification. So the physician's requirements to get the informed consent, the 24-hour waiting period, the parental permission required if I think it was a child under 15. And they replaced, or supposedly replaced, the trimester framework of Roe with what's called a viability analysis. So the point at which the fetus becomes viable, at that point, the government interest in this future citizen matures to the point where abortion can be completely banned. This is not, to my mind, a whole lot different from the trimester framework, because by the end of the second, the beginning of the first trimester, that's about when the fetus does in fact become viable. So whether Casey really made a major change in terms of the viability analysis is not clear, but the place where it was extremely important, it replaced the strict scrutiny analysis of Roe with a new undue burden standard. So remember, we were talking about standards of review. Strict scrutiny is the standard the court uses to review restrictions on a fundamental right. We talked about speech. You have to we look very carefully at laws that restrict speech. And but in Roe, in the right to abortion, maybe we don't look quite so carefully at restrictions. We allow the states to impose some restrictions. And the new, we're undue burden standard. So restrictions can only be unconstitutional. You see how the burden has shifted here. Now they're only unconstitutional when they are enacted for the purpose or effect of placing a substantial object in the path of a woman seeking abortion of a non-viable fetus. So you have to see that the statute in question was enacted purposely to put a burden in the path of the woman, or has the undeniable effect of placing such a burden. Created a jurisprudence of doubt. And I added that because that case opened by Justice O'Connor. There was it's called a plurality opinion. So there were these three that was the quote majority opinion. There was an opinion for the court. Liberty finds no refuge in a jurisprudence of doubt. And then again, 19 years after our holding that the Constitution protects a woman's right to terminate her pregnancy in its early stages. And they refer to Roe. How can they still question liberty, that right? And again, the United States, as it has done in 5 other cases, again asks us to overrule Roe. This is important because in Dobbs, which was argued in December, the United States Attorney General again comes in as an attorney regarding the more recent cases, but depending on when the cases are decided and which administration is in the White House and who has been appointed the Attorney General, the United States will sometimes argue on one side or the other. But Justice O'Connor said, and I think this is perhaps the best single statement about when government should be able to intrude on personal liberty. It is a promise of the Constitution that there is a realm of personal liberty which the government may not enter. Keep that in mind, by the way, when you start thinking about the vaccine cases, because there are anti-vaxxers and people who are opposed to mandatory vaccines who will bring up this statement and suggest there's a realm of personal liberty in that instance also where the government may not enter. After, we'll go quickly, these were the next 3 cases. These are the Carhart cases. This is Dr. Carhart. He was a friend of George Tiller, who was the abortion doctor who was shot at dinner when he was having dinner with his family. He had done some late-term abortions. Carhart got very upset about this. He was not an obstetrician. He was, I believe, either a general surgeon, but he picks up his friend's burden and he begins to do these very late D&E, dilatation and extraction, or dilatation and evacuation. It's also called or partial birth abortions. The court struck down Nebraska's partial birth abortion law. He wins here, in other words, in the state, but Congress passes a partial birth abortion ban. And if you ever want to see an interesting, I didn't put it in here, but Anthony Lipatino, who was also a 3rd trimester abortion doctor and changed his view, he's put out a kind of interesting video that you can find online. Carhart then sues Gonzalez. This is Attorney General Gonzalez. He's the Attorney General of the United States because now he's won with the state of Nebraska, but now that he's got Congress to fight, or the congressional law to fight. And finally, this comes to the US Supreme Court, and SCOTUS reverses and upholds the federal law. So the 2003 partial birth ban is good law. Okay, I'm not going to talk, well, maybe I will. There are collateral consequences related to the potential reversal of Roe. What about the 9th and 10th Amendments and the balance of power between the states and the federal government? And if you listened to the oral arguments in Cobb, you will see that the court, and it surprised me how, listening to them twice now, how very concerned the court was about threats to its own existence. If we reverse this, what's going to happen to us? Justice Sotomayor has made a prediction of a stench from a perception that the Supreme Court is merely another political body. But also, other people talked about, if we are going to get rid of the balance, what about other areas? What about a national automobile emission standard? I'm sorry. What about water use? What about traffic rules? Could there be a federal rule that we all must drive 50 miles an hour? I know that would make at least one person in this class very happy, but probably we don't. You just have to be careful when you cross the state line what the traffic rules are. So anyway, that's part of the consequences of potentially reversing Roe and sending everything back to the states. Will we end up with court packing? Will we end up with an increase in, what about collateral consequences of an affirmation of Roe? Roe may be seen not only as an exemplar of Griswold liberty, but as a rule of personal autonomy and bodily integrity, recognizing the limits of government power. Well, again, are we looking at vaccine mandates? What about end-of-life treatment or denial of treatment? What about physicians' autonomy? Gavin Newsom put out a speech a few days ago suggesting that if Roe's reversed, and he was particularly talking about another case we'll take a look at in a second, then he's going to do something similar with gun laws. Okay. 4 current cases. These are the ones that Dave mentioned 2. Unfortunately, now there are 4. One from 216, Hellerstadt and Jude Medical Services. These are both early cases. They came out the same way. Dobbs is the one we're waiting for a decision on. We should hear from, it was argued in December, but we should get a decision, hopefully, if the Supreme Court's not too chicken to put it out.
Is that Texas or Missouri?
I'm sorry.
Is that Texas or Missouri?
Whole Woman's Health is Missouri.
Never mind.
Oh, wait a minute.
No, is this a state then?
Yeah, yes, Dobbs is a state statute which has now risen to the Supreme Court. I put this in here so you could see where all these cases come from. Roe came from Texas, Louisiana, and Missouri. This is the Fifth Circuit. It is very conservative. A majority of its justices have been appointed by Republican presidents. Trump, all by himself, Trump has appointed probably 8 or 10 of the justices that sit on this court. And this is where not only did Roe come from there, which we've looked at, but also these current cases have come up now from this area. Even though the Northeast is where originally Griswold and Eisenstadt, these liberalizing cases came from here, and the restrictive statutes are coming from down here. So it gives you a sense of the division, geographic division, which we already knew about. And of course, California is way out here, basically aligned with the Northeast. Okay, Hellerstedt, and it's a 2013 Texas statute, imposed 2 abortion-related measures designed, they said, to protect women's health. Full admitting privileges for every abortion doctor. If you're going to do abortions, you have to have full admitting privileges at a hospital within 30 miles. The clinic must meet full ambulatory surgical center standards and upgrade building safety, parking, and everything else to meet the standards of a hospital room. Whole Woman's Health was a family planning clinic that sued to overturn this case, this statute, and it said it sued on the basis of the rule of Casey, said these are undue burdens in contravention of the rule of Casey, because it's difficult for the doctor to have full admitting privileges. It's prohibitively expensive for the clinic to have to meet these standards. So, and the district court, so they go to federal court, of course, with this, because they are saying that there is a federal constitutional issue. And the district court says, you know what, that law really is, and it does pose an undue burden. This is too hard, because a lot of these clinics will close, and women will have to travel a long way, and the state of Texas is very big, and this is going to be just too much.
Alexa Smith.
Oh, sorry, this is my daughter. Let me, who is, okay. I think
Donna, I'm sorry.
Go ahead, Dave.
Okay, I wonder if this is a good time to stop and we pick it up here after the break. I'm simply trying to get us in harmony, not in harmony, but accustomed to the new schedule that we're using. And that calls a stop at 11:30. So if we stop now, could you pick it up right here when we come back at Whole Women's Health?
I can, Dave, maybe only a short break. And the only reason for that is I'm going to my class reunion. This is APC weekend, and
Okay.
so I will not be able to stay a long time.
Well,
I think
we should go straight ahead. Let's go straight ahead so you can get there.
well, I can get there if we take a short break. So
Okay, but let's go. Let's go ahead.
Okay, then we're into these recent cases now. I'm sorry I didn't realize I had taken so long, but yeah, we started a little. Okay, Hillerstedt, Texas statute imposes these restrictions, and this goes up through the court system. First federal trial court, which is the district court, says it's an undue burden. Fifth Circuit says no, it's not, and we reverse the trial court. Supreme Court reverses the circuit court. So the Supreme Court reverses the Fifth Circuit and says this law is an undue burden. Now you see it's a 5-3 decision because Scalia had died, but it didn't matter in this case that the court was shy of a full complement of justices because it wouldn't have mattered, assuming Scalia was still there or a more conservative justice was there. It would have been 5-4. And so it doesn't matter. The decision would remain unchanged. So this wasn't the situation earlier where they were worried about a 4-4. Breyer, who, as you all know, is getting ready to retire and will probably be replaced by Justice Brown Jackson. He writes the majority opinion and said, yeah, they did amount to an undue burden. You have dissents then from Thomas, Alito, and Roberts. These three people are still on the court. And we don't know for sure how they are going to rule, but their point was there's no evidence of this being an undue burden. And anyway, these plaintiffs don't have standing to assert the right at issue because they are clinics, and their interest is really monetary. They want their clinics to stay open because they make money off of abortions, and they are only third parties, not directly affected. But the opinion of the court said no, they can bring up the rights of third parties. Kennedy joins the liberals. Remember, Kennedy now has been replaced by Kavanaugh. Okay, the next case, Jude Medical Services, 2014. Almost the same thing as the Texas statute. In fact, these two laws passed each other in the night. One's going up and the other one's coming down. Took the Fifth Circuit allowed the law to go into effect because it said doesn't violate Casey. It's not an undue burden. But Roberts provides the fifth vote by going with the conservatives. We get an argument in March of 2020 and a decision in June of 2020. That's a very fast for the Supreme Court. They said, look, we already decided this in Hellerstedt, and this is the same law, so don't bother us again trying to relitigate an issue on which we've already made a decision. Now, this is Dobbs, to which I've been referring all through. This is Mississippi law. This is now a little different. This is the gestational age law, passed in 2018, and you see it only gets to the court 3 years later, requires the doctor to determine gestational age of the fetus before proceeding with an abortion. So this is an attempt to comply with Casey and say viability, which is related to gestational age. And Dobbs says we're going to ban abortions after 15 weeks. And if you think about the quickening laws back in England 150 years ago, That's a very similar time period, a very similar standard. That's and Dobbs is the Attorney General, or excuse me, the health officer of the state of Mississippi. Jackson Women's Health, of course, is a Planned Parenthood version, or a version of a Planned Parenthood type clinic. Problem with this law is not only no abortions after 15 weeks, which is kind of early. It's still in the second trimester, except in cases of medical emergency and fetal abnormalities. There were no exceptions in this Mississippi law, this gestational age law, for rape or incest, and that, I think, was what is its fatal flaw. The Jackson Clinic sues. They get an injunction at the trial court level, which means that the law, their gestational age law, is put on hold. Health Officer Dobbs appeals to that Fifth Circuit again, and I said was very conservative. He loses there. That is, the Fifth Circuit upholds the trial court. But what has happened, of course, is that the Fifth Circuit is starting to learn its lesson. You know, we keep supporting these anti-abortion laws, and the Supreme Court keeps slapping us down. So by the time they get to Dobbs, the learning curve is slow, but even the Fifth Circuit can learn a little bit. Dobbs, the health officer representing Mississippi, then appeals to the Supreme Court. That case was just argued in December the 1st of this past year, before Christmas. And it's in the opening argument for the state of Mississippi, the lawyers explicitly urged the court to overturn Roe. It has no place in our history or traditions, says the state of Mississippi, and it shouldn't be here. These decisions belong to the people, by which they mean the states, because unlike other kinds of laws regarding life and death, this one comes out of the Supreme Court, and nowhere else has the Supreme Court found a right that gives one segment of the population the right to kill a living organism, another human. This is the only instance in which that right is somehow found and given to, in this case, pregnant women. So that's the issue. In the alternative, in case the court doesn't overturn Roe or isn't willing to do it, the state of Mississippi argues, well, we need a more clear standard of what an undue burden is. And I do agree with them on that. We need a clear standard of an undue burden if the court's going to retain that standard. We'll get a decision in June. It's very interesting to listen to the arguments. The lawyer for Dobbs, for the Jackson Women's Health Clinic, doesn't really argue in a clear way the constitutional issues, but says, look, we've been here now for 50 years. She mentions the Constitution and those amendments that we looked at, kind of repeating the arguments that Weddington made in Roe, but says, look, 50 years, women's right to live a full life, professional advancement, and autonomy require the court to affirm and reaffirm Roe. The justices asked very interesting questions. It's easy to find this case and listen to the oral argument, by the way, if you're interested. But if the general opinion is that even if the court does overturn Roe, which I think is unlikely, but could be wrong, most people think the court will stay its ruling at least a year to give the states time to react. So maybe we can revisit this in 6 months or so and see what they actually do. I put in a slide here about gestational age. this, but I'm not sure we're gonna use that. This is the last case. Texas, United States versus Texas, so what's called the heartbeat law. This is the most confusing law or statute that any of these Fifth Circuit states have passed. And I put a question mark here because we don't know when this, if at all, when the Supreme Court will rehear this. This case has been kicked back down, and the court said we improvidently granted cert, which means that it's up here too soon. We can't deal with this right now. The Texas legislature passed a law. I'm sure you've heard about it. This one restricts abortion after just 6 weeks of pregnancy, when a fetal heartbeat is usually detectable. It authorizes private citizens, including citizens residing outside the state of Texas, to bring civil actions against people for aiding a patient with getting an abortion. And this, you advise them, you counsel them, you drive them to the clinic, you advise them to seek a certain physician or a certain clinic where they could probably get an abortion. This is a very restrictive law. Bill is an attempt to kind of go around the Supreme Court. It doesn't authorize state officials to enforce the law or bring criminal proceedings. It's a civil law. It's a little complicated to understand. Even I've looked at it several times. I'm not sure even the law professors understand, because it goes back to an old railroad case from the 19th century for looking for its base. But the reason the court says we're not going to decide this case is that nobody's actually attempted to enforce it. That we don't have any private citizens, and even if private citizens did bring a civil suit in the state of Texas against someone who was aiding or abetting an abortion, that's state law. And the federal government, and this is the 11th Amendment, so we won't go into that. But anyway, generally, the federal government cannot interfere in a strictly state law and the decisions of a state Supreme Court. So the Supreme Court is not even sure if it has jurisdiction, certainly not until after there's a case and somebody disputes and tries to bring a constitutional argument. I don't know if I've made that any clearer, but the Fifth Circuit stayed the injunction which the district court had put on this law. It said, no, you can't enforce this. So right now, that Texas law is still in effect, at least as of the last few days. And we'll see what happens in the state of Texas. So that, if it ever gets to the court, we'll find out. And then you notice here, the United States now is the party. Remember, Justice O'Connor said, here's the United States again, trying to get us to overturn Roe. Well, the United States is arguing against the Texas law because we have a liberal administration. So we have a, quote, liberal U.S. Attorney General. This is just this, you can look this up. I got this from Guttmacher website. They talk, this is all the states that have abortion bans by gestational age. There are a few down here that have no gestational age ban at all. Some who have viability. California is in here, I think. Yeah, there we are. So in California, post-viability abortions are still against the law. And those of you who've ever seen a late term abortion, as I did once with a saline abortion, I think you find the California position fairly reasonable, although Governor Newsom has recently issued a statement suggesting that we should move from this category down to this category. There are states that are trying to move up from here to more restrictive categories. And of course, Texas isn't on here yet because this slide is a couple years old, but it would be trying to move into the into that lower age category at which abortion. Oh, this is just the California Proclamation of Reproductive Freedom, in which, as I said, California is suggesting that there should not be a limit. And American Academy of Pediatrics versus London case I hate, because it makes 12-year-olds able to elect an abortion, and now that even that is has been abandoned, at least if Newsom. Okay, I'm going to skip that. These are Hyde Amendment issues. Hyde Amendment is still active. The Equal Access to Abortion Coverage, that's the EACH Act of 2021, would prohibit restricting insurance coverage. That's ACOG goes back and forth. There's a question about racial distribution. Who gets? I thought you might be interested in resident trading issues. At Loma Linda Loma Linda, the OB/GYN residency trainees, they have about 9 residents a year at the 4-year program. And accord with ACOG, we have all residents have to have done at least 20 abortion or abortion-related cases over the 4-year training period. That's necessary that we comply with that. Otherwise, we'll lose accreditation of the residency. But since no elective abortions are performed at Loma Linda, residents rotate through a local family planning clinic where abortion procedures are done on an outpatient basis. Most are medical, some of them up to 22 weeks. I checked, this is the same as at Georgetown, although at Georgetown, the residents have themselves gone out and established a free clinic where they do abortions, those that wish. Residents may elect not to participate in elective abortions. So in other words, you have an institutional and then also a personal right not to participate. About half of our residents in a given training year, cohort year, claim the religious exemption, so they don't do elective abortions out at the clinic. However, because we're a tertiary care center, we get a lot of transfers of women with a variety of life-threatening problems like placenta previa and so forth. And it's also a referral center for abortion in cases of fetal anomalies. So we get trisomy 18s, anencephalies, things like that, that are incompatible with life. And those abortions are done at Loma Linda. They're high risk. And so these residents that need the experience get them. And they haven't had any problem yet with any of our residents not graduating with the required 20 cases. And here, and I don't know about Georgetown, but before any pregnancy termination for any reason, we require an ethics consult. And this, of course, is the nub of the issue. As soon the gametes are human, when they combine, they're human. But at what point do they become a person? Remember, Justice Blackmun said, we don't know. The state of Missouri thinks it does know. And somewhere in here is okay, I quoted Blackmun again. This is my daughter, and this is what happens when you don't get an abortion. And then I had some questions. A fetus can be a person in some legal settings, like probate for inheritance law, tort law. You can damage a child in utero. A lot of questions related to that. What do you do with mothers that ingest cocaine? And are they harming the fetus? Should they be held liable for child abuse? Justice Thomas asked that question in Cobb's when he was doing his interrogation of the lawyers. How should the exceptions, affect our discussion? Does it say anything about social values? We're willing to give the fetus or the unborn child inheritance, property protection, but maybe not abortion protection. I showed you at the beginning the copy of the latest issue of Law, Medicine, Ethics. What about financial support of hospitals that won't do abortions, won't do sex change operations, won't perhaps turn up the morphine at a patient who requests the end of life in that fashion. And then, and this Dave will pick up the discussion, is it ethically okay for religious medical training programs like Loma Linda to use the charity clinics for resident training for procedures they refuse to accommodate in their own facilities? When I did this last week, one of the residents, actually it wasn't a resident, it was a faculty member, asked this question or brought it up. And defend your answers is just a standard law school final admonition. And I think we are done. So maybe Dave, or are you there, David? If you want to take the 5 minutes now, I will have then about 25 minutes for discussion with me in it, and then you all could continue all day.
Okay, so if we take 5 minutes now, we would be back at noon or so, and then we could chat with you until, say, what are you thinking of, 12:15, 12:20?
Yeah, somewhere around there, 12:25.
Okay.
I'm
Go
having
ahead.
people arrive here who are going to be going to my reunion with me, so I will have to break at some point.
Sure. Wow, you've given us lots to think about. I've written down 7 different issues. The question of originalism on the law, and then the question of 15 weeks, is that a good idea? We need to look at the trimester. I think we may need to have some images of human gestation, the SDA guidelines, the 5 R's, I call them. What can the court do? It could, retain, revise, refer, remand, or reverse. Whoa, those are some options before the court. And then we have the church-state issues, and then the personal freedom issues. Now, when we come back, I'd like to begin with Donna suggesting what she would do if she were on the Supreme Court, if she's willing to be that self-disclosive. But Donna doesn't have to tell us that if she doesn't want to. But I think it would be interesting to know what she would think about the case from Mississippi, 15 weeks. And I understand some people say the heartbeat one is 6 weeks. Is that right? You pick
That's
up a
correct.
heartbeat at 6 weeks. So in
Yes.
fact, Mississippi's wanting 15 weeks as the cutoff point, and Texas wants it 6 weeks. So
Correct.
that's half of the first trimester. So yeah, let's hear what you have to say. 5 minutes from now would be noon in California. Okay, thank you.
Okay, how do we?
I think
Loma?
David was before me.
Okay, David,
Donna will be here. Okay.
David?
I think Donna's not quite back.
Oh, okay.
Is there anyone else who would like to make a comment or raise an issue or ask a question? Be sure to raise your hand so Forrest can see you.
Yeah, I got it.
Well, if David is not available, I can start.
Why don't you go ahead, Simona?
So I want to ask a different question. Is it ethical to force a woman to carry a child she doesn't want, considering all the implications of the pregnancy, complications, potential death, to go to the end? Is it ethical to force a woman to do something she doesn't want to do? And I'm going to give you an example. So during the war in my home country, there were women who were taken as prisoners and held in concentration camp for the amusement of soldiers, where they were repeatedly raped and only left, allowed to leave once they were in a late stage of pregnancy, and then delivered back to their families for their shame. It's, rape, for example, is a weapon of war, among other things. And many of these questions that people are asking, they're only asking about the rights of the fetus. But nobody is asking about the right of the woman. It is her body. She should be allowed to decide whether or not to carry the pregnancy.
To whom are you addressing that? Are you addressing that to Donna?
I'm
This
sorry.
is just a general comment. So
Okay.
we were talking about ethical frameworks, right? So I'm asking, is it ethically permissible for a woman to be forced to carry a pregnancy she doesn't want because the state tells her, or the government tells her, or the religion tells her, or anybody else tells her?
You want to,
Me that question?
what do you think?
I guess I will go back to a little more of the basics. If you get, or if a woman gets all the way to the 8th month, I think there really is a fairly strong question about whether that baby, however it was produced, needs, to bear the very brutal methods by which an abortion at that point is effected. Either it was saline. I saw one saline abortion when I was at Kaiser. I hope never to see another one. We had an 8-month infant delivered, macerated, just in awful condition. There in the nursery, survived for about 48 hours going. It drove the nurses crazy. I would get in and out of the nursery as fast as I could, but the obstetrician said, please, please do not try to save this child. And so we didn't. I'm not sure whether that was the right decision or not. It's a very difficult question you ask. And you, of course, you've set it up with some pretty horrible circumstances. And what happens to that child if it's delivered? You don't know who the father is because the mother's been raped so many times. I think that's what I only heard part of what you said, so I believe that's the circumstance, and that's what makes this an ethical dilemma. At what point do you decide, well, maybe that?
Yeah, I mean, what I'm trying to say is that, there are certain reasons why we talk about a child when it's viable and when it's not viable. And I think there is a big difference in the right of the woman to make decision, at certain point, right? If the pregnancy is carried for whatever reason, and I think most people would accept this, that the child is capable of surviving, then I think it is reasonable to say, okay, this is now a person, and that person has the right to be delivered. But I'm talking about all these laws in the first weeks of the pregnancy, the first trimester, some of it second trimester, where they're trying to basically force a woman to do something she doesn't want to do. And I cannot see ethical justification for that, no matter who says what, because the woman should have the right to make the decision for herself. I was looking yesterday through some of the information that's available on the internet about a variety of issues. I'm going to give them to you. Okay, 25 to 30% of all girls and 14 to 20% of all boys are sexually abused before they turn 18. 95% of teen prostitutes and at least 1/3 of female prisoners were abused as kids sexually. We are talking about maternal death in the United States is the 6th cause of death among women the ages 20 to 34. We are the #1 in terms of maternal death among all developed countries. It's shameful to admit it, but that's where we are. Average cost of pregnancy and delivery, $5,000 to $11,000 for uncomplicated delivery. Cost of abortion, $350 to $1,000, depending on the timing. Paid maternity leave. Sometimes you have it, sometimes you don't. Most can get up some unpaid leave. Average recovery, 6 months. Average basic physical recovery after pregnancy, after delivery, 6 to 8 weeks for uncomplicated birth. And then we go to cost of childcare, cost of raising a child. We're talking about hundreds of thousands of dollars. Well, while we still have, for example, minimum wage $7.25 per hour for regular employees, $2.13 for tipped employees, the woman would have to work at the lowest cost of childcare. She would have to work a minimum of 13 hours per week just for the cost of childcare. If she is a minimum wage, if she is a tipped worker, she would have to work 45 hours a week just to afford a childcare. And so we're talking about, things where we are putting a burden on people because we have a certain ethical standard. We are not asking, okay, what about the lives of people? So my point is that I think everybody wants to get rid of abortion. Nobody goes and says, oh, abortion is a great thing. We all want to do it. The question is how we do it. And my answer to that, we need to create a better world.
Okay, Dana, I think we need to press on here.
I address just one point that you made. A fair amount of the last part of your comments related to economics and economic burden on the mother. It was interesting in the Dobbs argument. Justice Barrett, Amy Coney Barrett, pointed out that motherhood, parenthood is not a necessary component of pregnancy. In other words, you can give the child up. The state takes children away from parents for a variety of reasons, and other circumstances could take it away in this kind of circumstance as well. I'm not sure how good that argument is. The response is, well, adoption's always been available, but that was one point that was made. There are a whole variety of the social circumstances and other factors in the economy and in the society in general that you're talking about, which are I can't dispute any of the numbers, because I knowing you, I'm sure they are well based in the literature that you've been reviewing. Having said that, the issue before the Supreme Court as a constitutional issue is not that abortion is a good thing, as you've said, but does a right to abortion, is there such a right? And if there is, does it really exist inside the United States Constitution? Or is it fair to say that it does? Remember, the right to end your life, like Washington versus Glucksberg and some of the other cases, those are laws that were passed and affirmed by votes or by legislatures that were elected by the votes of the people. That's different from this one, in which it's the Supreme Court has, as perhaps the dissents suggested, it's created by the court. Not to say that it doesn't exist. And if David wanted me to suggest what I would do, I am very glad, not that there was ever any danger that I would be on the Supreme Court, but making a decision, I think I would probably draw the line somewhere in the middle, as the court has already done, that they did in Roe, Casey. I don't know about how I changed the standards of review, but first trimester, when you're sort of barely pregnant, if that's a state that really can exist, if you could be a little bit pregnant, I can see where the right of the woman definitely is paramount, and abortion should be available. I don't like it just for birth control. I had a 12-year-old who was pregnant, no problem there for me to refer her for an abortion. I had a 16-year-old who was pregnant for the second time, had been referred for an abortion by me the first time. We were still seeing 16-year-olds in pediatric clinic at that time, and then came back less than a year later, pregnant again. And I sent her over again to OB and got an angry call from the OBGYN department saying, look, give this kid birth control pills. I already did that, but she doesn't take them regularly, and now she's pregnant again. That's a problem with someone who just is extremely careless or negligent and just repeatedly gets pregnant and is using the OB department or the abortion service as a method of birth control. Third trimester, late third trimester, especially, as I said, I know we're forcing someone to continue to carry for another month or 2 months, but at that point, it's very difficult, especially with the dilatation and extraction. I mean, when the baby's literally torn limb from limb, or the head is crushed in order to get the infant out of the uterus. I'm sorry, at that point, I would say I would generally not condone late term abortions. So I don't know if that answers your question, Simona.
Thank you, Donna. I'm trying to find David on here. It was on and then it's off. David, are you on?
Yes, but I think my question was largely answered. I was just gonna put forth a hypothetical question that if Donna were a state legislator, what would be the permissible length for abortion? And I think she answered it as what, 4.5 months essentially?
Yeah. So it's difficult. It's difficult. Trimester, you almost want quadrimesters because of the changes that go along in the course of those 40 weeks. The beginning of the second trimester, still pretty early, still pretty easy. Medical abortions, where the two-drug method of inducing abortion still works well. You get toward the end of the second trimester, 22 weeks, it becomes more difficult. And in fact, now everyone, sometimes a 22-week-old with a little support can survive. So that line is also moving. And I don't know if that answers your question, but I think viability is a pretty good.
Okay.
Thank you.
Thank you. Hey, Donna, I would like to ask you a question, if I may, in regards to, and I appreciate your outlining of the legal parameters here. I thought it was very good. And I think I would love to discuss state rights versus federal rights sometimes. I agree with some of them, I don't agree with others, and also original intent. So thank you very much for that. I have heard, now I don't know who they are, but heard that if we banned abortion today, abortion would continue, but under less sterile conditions. Do you have any comment on that, Donna?
No.
Okay.
There are still, back alley abortions. They're just not very common because the ubiquity, at least certainly in this state, of the availability of family planning clinics. And the state of California, I didn't read the full, but you could go online and find Governor Newsom's, it was 2019 statement of reproductive rights in this state. The state will pay for anybody who needs the money or who needs payment. And the state of California insurance companies have to fund or have to pay for. And that's part of the Covered California. So anybody that's on Covered California has.
Okay, well, thank you. Okay, I want to go to Eduardo. Eduardo?
Thank you, Forrest. Donna, in the case Dobbs versus Jackson, I saw that instead of bringing a new idea, they want to bring new judges.
Hmm.
And the other argument was that they want to back to the states.
Mhm.
What is your thinking? And by the way, let me say something else. Ellen G. White said that the government of the United States is going to endorse the dogmas of the church. Do you see abortion as an issue of the church? Because most pro-life are religious people.
Oh, boy, the last one is a difficult, right about the issues in Dobbs. There was apparently statement by the legislators in Mississippi that why are we coming back now? Well, we got new people on the court. The court's changed, and so we're hoping now that we can get Roe overturned. And the court itself is very aware of that kind of statement and very concerned about it, and appropriately so. I thought it would have been better in listening to the oral arguments had the lawyers for Planned Parenthood, they were good lawyers on both sides. It's definitely worth listening to. But Justice Sotomayor, for instance, and to some extent Justice Breyer, were very concerned about the effect on the court. If we overturn this, if we reverse Roe, what will happen to us? What kind of criticism will we get? And Sotomayor used the famous statement, can this court survive the stench? She used that word, that will come if we're seen as a merely political body. And of course, you may have seen Chuck Schumer shaking his fist on the courthouse steps of the Supreme Court when Kavanaugh was appointed, threatening the court and threatening Kavanaugh himself. If you overturn Roe, or if you do something we don't like, you will feel the pain of that kind of a decision from the legislature. And I think the court does not want to be seen in that way. So you're correct. And I'm sorry, Eduardo, what was the second question you had? Or the second thing
Ellen White predicted that the United States government is going to support the dogmas of the church.
The dogmas. Well, the church is, I don't know about that. I probably ought to punt here to Dave or to any theologians that might be on the program right now. Dave, what about Ellen White and whether or not we're going to support the dogmas of the church?
Well, really quickly, because I know you have to leave, but first of all, she doesn't say anything explicitly about it herself. Secondly, she does say a lot about the value of human life that can be used as applying to this. And thirdly, there has in Adventism been the idea that we should guarantee freedom on this matter, because restrictive abortion laws are another way the Roman Catholic Church is trying to get control of the government. That is one of the arguments we find in Adventism. But thank you, Donna. We're going to have to conclude your participation, and I think we're so close to the end, we might as well for the whole group. Yeah, go ahead.
Jeff is reminding me, I have another 10 minutes. We got a text from someone who's coming that they're going to be late. They've stopped to do something else. So
Okay.
if you want to talk for another 10
Sure.
minutes here.
Who's
I don't
up?
have any hands, David.
Okay.
Okay.
Can you see me?
Wait a minute. I just had a hand come up.
Anastasia.
Rod Corker.
Anastasia and Rod, I guess.
Okay, thank you.
Okay, which one came up first?
Let's go with Anastasia first.
Okay,
Thank
Anastasia.
you. Thank you very much. Donna, it was wonderful hearing you and seeing you. And one of my questions is that about society. And I don't know if the Adventist Church, I know that the Orthodox, the Eastern Orthodox, the Greek Orthodox Church and Catholics have tremendous programs for mothers and other siblings to feed and take care of that mother, and then the child, if she doesn't want it, to put it on for adoption, etc. And so as a church, does the Adventist Church has anything like that? And the other thing is, I'm progressive in almost all or most of social issues, but I disagree that because it's our body, we can do everything we want. We cannot get drunk and kill somebody. We cannot have the virus and not wear a mask and hurt somebody and things like that. So I lost my first child in my 20s on the 5th month. It was the most beautiful, perfect baby. It was for no reason, we don't know why. But if we care about the grass and the breeze and the trees, I think we should take without penalizing the mother, especially in terms of incest and rape. At the same time, the other extreme of using it as a, probably it's very small number, but using it as a birth control method or things like that, I think as a society, that's the craziness that most people, I don't know most people, but many people that are against abortion, they don't want to pay the price of taking care of that mother and that child once they're born. And, you know, so if we want to do the really ethical thing for a life, then we should, our churches and everything else and our government should take care of that child. And so what is your, what do we know about the Adventist Church? Do they have organizations like that? Thank you.
As far as I know, the church doesn't have any specific committee or subcommittee that deals with the issue you've been describing. I do know when I was in college at Southwestern, a couple of young women, one in particular who got pregnant was expelled, but the boy responsible was not. that unfortunately I think has been the course of these things in the past, at least. But I understand I think your point is good. Maybe we do need some active organization or subdivision of our church that deals with these issues. And maybe Dave, we do have something like that, or if there's a social worker on here today might know.
I mean, really, we should put the action where our mouths are. And so they will have shelter, the children and all these things, you know, it's so much better than just building fancy buildings. And I'm not talking just the Adventist Church, I'm talking about all churches. Thank you so much.
Go ahead, Forrest.
Okay, all right. I've got Rod Corker now. Rod?
Hey, Donna, good to see you, and thank you for that presentation. I'm interested in the theologized history of the subject matter of abortion. I know a number of mature-aged Seventh-day Adventists who say that abortion, the Bible and the scriptures are silent on the matter of abortion. So the argument becomes, why is abortion elevated to the attention that it's got? It's a social disorder that really doesn't warrant this degree of attention. But somewhere in history, morality, this became a moral issue and got fused with public policy law. What are the earliest writings that you know of whereby those two matters became fused together? There has to be antecedent events, I think, before the 18th century, when this thing became more inflamed and much more a public policy moral issue. But what are those earliest readings that you're aware of?
Well, I'm sorry to have to plead ignorance, I can't say the earliest, I did point out the Hippocratic Oath, and for some reason, that's, 400 BC. We wouldn't call that a reading or theologizing necessarily, but it's obviously for Hippocrates, if he really was the person who constructed that oath, and that's another argument. But anyway, it's been quoted a lot. I didn't say it, but Justice Blackmun was very concerned about the Hippocratic Oath and physicians' pledge to support life. Roe was argued twice. It was argued once when the court did not have a full complement. And as I said, they didn't want to have a 4-4 decision. So they waited until they had a full 9. And then it was re-argued. And then it was assigned to Blackmun, who was a junior justice. Nobody wanted to write that. None of the justices wanted to write it. So he had worked at Mayo, as I said, as in-house counsel for 10 years. He went back to Mayo that summer and worked in the Mayo Library, and it came up with what eventually became the Roe versus Wade that we have now. And he said, as I quoted, look, we don't know. Theologians don't know. We don't know either. And we can't make a decision about when life begins. On the other hand, by the time we get to 18th century and 19th century England, there's the Ellenborough statutes, in which for the first time, or at least there's a specific penalty attached to abortion or attempted abortion before quickening. And if we think of quickening as about 15, 16 weeks, then at that point, the English law is not just common law, but statutory law is willing to impose severe penalties. And I always make the joke about whether death was worse or deportation to Australia was worse. You could kind of take your pick. But they were considered, I guess, approximately equal. But that doesn't specifically answer your question. One of the questions or one of the issues is when did Catholic theology become Protestant theology? Because as you saw from the map, it was the immigration of a lot of Catholic country immigrants to the Northeast. I mean, most of these people came in through New York. And these laws became especially severe in Boston and New York in the Northeast. But by the time we get to the cases, we're down in the southernmost part of the United States in the Fifth Circuit. Maybe the circus, some people would think is correct. But in any case, that's what happened. And the answer is that I can't answer your question, Rod.
Good effort. Thank you. And I do suspect that when I get to research this, I'll find it rooted in Catholicism somewhere, the early Catholic Church. I just not sure where I'm going to find it in any other place.
Well, it's the basic, the basic mantra of the Catholic Church is that we should always be open to the transmission of life, and that's the basis for the anti-birth control position that the Catholic Church, or at least the European Catholic Church, has taken. And of course, the natural extension of that is anti-abortion.
Yeah, thank you, Donna. Enjoy your get together.
Oh, I will. Yeah, people you haven't seen. Our class of 69 has had a reunion every single year since graduation, except one, and that was COVID. And by the way, Jeff told me I need to point out my colors. Can you see? These are the colors of the Ukrainian flag today.
I do think we better quit now, don't you think, Forrest?
I'd like to get Tim Price on if I could.
Okay.
Then I'm going to turn it to you.
Okay.
Tim?
Yes. I spent a number of years working with therapeutic boarding schools, and it became obvious to us, we had a disproportionate number of adopted kids. even among families, where they were placed in homes immediately after birth. So it seemed to us that primary attachment, emotional attachment, was sometime in the womb. And I'm curious if anyone has run across any good studies that show, that kind of activity going on in the brain and when that might be taking place.
Where's Dr. Cupino?
Okay, Donna?
Well, I don't know anything about any studies, but I would say yes, that there is attachment, I'm sure, going on in the womb, which is one reason why Justice Barrett's suggestion that, well, you can just neatly divide parenthood from pregnancy is, I think, a little bit of a weak argument, at least for a lot of people. I was a resident at Loma Linda when we had a young woman coming in from Colorado who delivered, unmarried young woman, who delivered a set of twins, baby A and baby B. We had them in the nursery, cute as could be. And the general rule was that the social workers recommended that the mother in that kind of a situation not even see the children. And but that mother was a college student, would come down the hall in her hospital gown and slippers and stand at the window of the nursery and stare at those two little babies until social services came and took them away. And she didn't change her decision. She went back to Colorado and I presume continued her life. But it struck me very poignant at the time that how difficult that was. And if society had been a little more accepting and a little more helpful, and I have a pretty strong opinion about the father's responsibility in cases like that, it might have turned out differently.
Okay, thank you, Donna. David, I'm going to turn to you for our termination of the regular portion.
Okay, I'll have the benediction, then we'll conclude Facebook, but we'll leave Zoom on as long as people want to continue talking. After Zoom doesn't hear you talking for 45 minutes, I think it is, it will turn itself off. So we can leave without any worry about that. Thank you, Donna. Lots of work on a difficult topic. It's not only intellectually challenging, but emotionally wrenching, I think. It's a tough issue. Okay, here's the benediction. The Lord bless you and keep you. The Lord make his face to shine upon you and be gracious to you. The Lord lift up his countenance upon you and give you peace. Amen.
Okay, I'm going to turn the recording off on the Zoom.
All right, we're no longer